It's already the appointed time. May I call the meeting to order? Welcome to the 7th meeting of the Bills Committee, and I also like to welcome representatives from the Constitutional and Mainland Affairs Bureau, Youth and Home and Youth Affairs Bureau, and also the DOJ. When we stopped at the last meeting, we were looking at performance monitoring mechanism of district councillors. We were looking at page 48 of our marked up copy, part 6A. Now, we have already asked questions about this section. I'd like to know whether there are further questions from members. If not, legal advisor, can you give us your views? Thank you, Chair. Just for members' information, in yesterday's discussion, members were concerned about the addition of provisions to perform to monitor the performance of members to CAP 5.4. There were questions on the powers of the monitoring committee and also their powers and whether the district council members concerned are entitled to make oral submissions or representations. In fact, for similar disciplinary procedures, usually there are provisions to provide for the powers of investigation and also the rights of the persons under investigation concerned. Take the accounting and financial reporting ordinance and also the social worker registration ordinance. There are provisions to set out the items I just mentioned for members' information. Home and Youth Affairs Bureau. All right, powers. Will you follow the usual practice and have them set out in the ordinance? Now, the legislative intent is to deal with these issues administratively. It's true that there are provisions in some other legislation, but even for disciplinary inquiries of civil servants, we do not have any legislative proposals or provisions. And as for the members under investigation, well, they will be allowed to make oral or written representations. There will be sufficient information for the subject to let them understand his rights, and he will be given an opportunity to make representations. But you need an empowering provision, right? You talked about the administrative power, but where does that power stem from? In our administrative guidelines, we'll have the procedures. We do not have any empowering provisions in the law because, as I mentioned yesterday, the committee can require the member concerned to provide information, and they're supposed to do so, and we will have it set out in the administrative guidelines. Can the DOJ explain to us where the administrative power stem from? Thank you. We have mentioned that in the ordinance already. Under 72C3, the supervisory committee is to conduct the investigation to then paras ABC follows. For instance, to establish whether the facts on which the allegation is based are true, give his opinion on whether the established facts constitute grounds for imposing sanction. Legally speaking, this provision already empowers the supervisory committee to conduct an investigation. Thank you. Mr. Lo Kwok, I agree that for these sections we are scrutinizing, they already empower the supervisory committee to conduct investigations. And then the secretary can also issue guidelines. However, I share the concerns of members. At least we should set out the rights of the committee as well as a member under investigation. Now, perhaps it will be more appropriate to call that a committee of inquiry, and also its power to obtain evidence, and also the right of the member under investigation to make representations. I understand that the administrative guideline is going to contain the details, but then given that we have these provisions on misconduct and sanctions, the respective rights of both parties should be set out here. I don't think that will be very complicated or lengthy. An expression of opinion. Any response, please? Secretary, well, we heard members' views. We will discuss with the DOJ again to see whether any amendment is needed. All right. Mr. Chen Xiu-hong. Thank you, Chair. Also on the same point, let's say there are no provisions in the bill to set out the terms of reference of the supervisory committee. And I'd like to know the legal basis for the supervisory committee to summons witnesses or accept evidence. What rights do the district council member involved have to make representations? Because one of the sanctions can be suspension from duties, because we have appointed district council members as well as elected DC members. There is no employment relationship between the secretary and the district council member. Now, if the supervisory committee invites the member to come forward to give evidence, and if the latter refuses, then you will put the supervisory committee in a difficult position. There might be complaints against a certain conduct of the member, and the committee has to gather evidence before compiling a report to the secretary for making a decision. If in the process of investigation the scenario I referred to really happens, then how should the situation be handled? If you do not set out the power of the committee in the law, then I'm afraid that there will be operational difficulties. It may not be the case that both sides act in a gentlemanly manner. We have seen incidents involving past district councils. Shouldn't you put it more clearly, the powers and also rights and obligations of parties concerned in the bill? Secretary, I agree that the procedures should be clearly set out. But should it be set out in administrative guidelines to be issued, or should it be put in the law? We believe the administrative guidelines can be more flexible and expeditious in responding to situations. Now, if the other side is uncooperative, even if you have legal provisions, the other side may not necessarily be cooperative. For instance, we have had select committees set up by this council, but the persons under investigation were not cooperative. But then the select committee could still come up with a report based on its findings and investigation. We will clearly set out the procedures. For instance, the person being alleged will have an opportunity to make representations, and there must be sufficient evidence. And then the member under investigation must be informed of the report. I'll see if my colleagues from DOJ have anything to add. Mr. Mui, thank you. Thank you, Mr. Chen, for your questions. With regard to the investigation procedures, now the Supervisory Committee is responsible for conducting the investigation. Must we give him powers in the law for investigation? Now, in principle, such powers can be delegated to the Supervisory Committee. But then we also have to consider the extent of misconduct to be tackled by the committee. Now we are talking about alleged misconduct of a member during a council meeting. So in designing investigation powers, we will consider striking a right balance, the seriousness of the allegation, and whether there should be statutory powers for the committee concerned, such as the power to summons witnesses and to impose sanctions. I think we have to strike a balance here. Our understanding is, in the current mechanism, the policy bureaus have given due consideration to these factors. So we have not provided any statutory powers for the committee to summons witnesses and to gather evidence or to take evidence. Perhaps the administration can reconsider the point I made. You may want to use your administrative guidelines, but you can also consider empowering the Supervisory Committee here in the bill, because the investigation may involve third parties other than the district council member concerned. And as far as the third party is concerned, if there is no legal basis, there is no way to compel third parties to cooperate with the investigation. So it would be difficult for the committee to get hold of very critical information or evidence. Now, in your administrative guidelines, you will not give the committee power to summons witness and to require the production of documents, right? Yes, this is very different from the powers enjoyed by just alleged co-members, because we're talking about the investigation procedures. We're not empowering the committee to summons witness and for the production of evidence. Of course, there will be clear procedures for the member being alleged to state his case, to make representations, etc. Now, if a certain party is not willing to provide evidence or to give evidence, then the supervisory committee is entitled to compile a report and state the facts. And then if the party being alleged feels aggrieved, then he can make representations. The member has to cooperate with the supervisory committee, and the person can be the one being alleged or the one who makes the complaint. And if there are problems with the procedures, then the decision of the secretary is still subject to judicial review. Yes, the party who doesn't agree to the report can lodge a judicial review. Mr. Shukafai, 72C investigation on misconduct of members. 3. The supervisory is to conduct the investigation. Now, for police officers, when they are being investigated, they might be suspended from duties. I'd like to know whether the same will apply to district council members. And 72C4, the supervisory committee must submit a written report to the secretary as soon as practicable after the completion of the investigation. I'd like to know whether the report will be made public as well. Thank you. Very clear. Thank you. Mr. Shield asked whether the member will be suspended from duty during investigation. The answer is no. Secondly, in our administrative guidelines to be published, a copy of the report will be given to the person being alleged, but at that stage the report will not be made public. Thank you. Mr. Chen Xiu-hong, second round. Thank you, Chair. Assuming that the supervisory committee has already submitted a report to the secretary, who feels that the situation is quite clear, and he decides to suspend the office of the district council member concerned, I'd like to know the manner you're going to serve the notice so that the district council member knows as soon as possible that he will be suspended from duty from a certain date on, because the member may not be physically in Hong Kong and he may not have received notice, and unknowingly, because he hasn't received notice, is still carrying out his duties. What will happen? And I'd like to the date of suspension, will it start from the date when the secretary signs the certain notice, or on the day of service of the notice to the member? Now, the manner of serving the notice. We are thinking of a written notice, and it will be served to the member in various ways to ensure that he receives it. It can be sent by registered mail, and also there will be a postal box, a mailbox of the district council concerned, and so he has the duty to check email. I have to confirm what a member can and cannot do, because a person might have done something or made a decision in his capacity as a district council member. If he only receives the notice sometime after, and before that he has acted in his capacity as a district council member, he has acted in that way unknowingly. So how will you handle the case? How will you handle this situation?
HYAB. Thank you, Chairman. This may be in relation to 72C 72D, that is sanctions imposed on members. If the sanction is a suspension, then we would specify clearly the duration of the suspension period. Now, if that district council member may deliberately ignore the mail, however, the duration of the sanctions would be specified very clearly on the letter. Now, before the suspension period kicks in, he or she is still a council member. Of course, he can act in the capacity of a DC member, but we will rely on the suspension period specified on the letter. Any other questions? Now let's continue with the clause-by-clause scrutiny. Next, 72D. Thank you, Chairman. Now we are at 72D. It specifies the sanctions to be imposed by the Secretary in accordance with the recommendations and the findings of the investigation. 72D1, the Secretary may, after considering the reports, issue a letter of persuasion to or impose any of the following sanctions on the member as the Secretary considers appropriate. These include warning, financial penalty, and suspension of functions and duties as a member. Subsection 2, the amount of financial penalty to be imposed would be decided by the Secretary, and the penalty would be deducted from the member's remuneration to which the member is entitled. Subsection 3, during the suspension period, the person under charge cannot act as a member, and the person must not do anything for the purpose of carrying into effect the functions conferred under the ordinance. Now, the person will not be regarded as a member for the purpose of Section 86, so the privileges and the protection offered to the member would be suspended as well. Subsection 4, this is in response to the previous subsection. That is, despite subsection 3C, the person is entitled to be reimbursed the operating expenses incurred by the person during the period of suspension. Subsection 5, for the purposes of Section 26A5, the person will not be deemed as absent from a meeting of the District Council, because 4 consecutive months' absence in District Council meetings with no valid reason would be deemed as absence without valid grounds. Subsection 6, we would issue a written notice to notify the member of the sanction. Subsection 7, if a person acts or claims to be entitled to act as a member of the Council while his function and duties has been suspended, then the Secretary for Justice may apply for an interim injunction. Thank you. Mr. Kwok Wai-keung. Thank you, Chairman. This is a rather long subsection. I have several questions. 72D1A and B. The sanctions include warning and financial penalty. Now, in practice, would there be a cumulative mechanism? Let's say if someone committed a misdeed or misconduct more than one time, will the second time still be a warning? Will there be an escalation of sanction? Now, we are worried that the person may be given the same punishment even if he repeats the misconduct. The same applies to financial penalty as well. So that's my first question. And also whether there is a validity period for warning. Now, for marks deducted from your driving license, after 2 years' time, there will be a clean slate for the driver. 72D 3A. When a person is suspended, the person must not act as a member. Well, but every council member has their own district offices. So will those offices continue to operate? The office is, in effect, conducting the functions of the member. So can the office still issue official letter to departments in handling complaints? Now, during the suspension period, all operating expenses incurred will be covered. So if the district office is allowed to continue to operate, will the salaries and miscellaneous expenditure items be reimbursed as well? 72D bracket 7. If a person has been suspended and still acts or claims to act as a member of the council member, the Secretary for Justice may apply for an interim injunction. Now, concerning the responsibilities and the cost pertain to the interim injunction, will that be paid for by the public coffer, or will the person under charge be responsible for that cost as well? Now, my next question is pertaining to 72E. I will save my question till later. HYAB, 4 questions. Thank you. Mr. Kwok's questions was about a cumulative mechanism concerning the punishment. There will be one. Now, for first offender, only a warning would be given. For repeated offenders, there will be a financial penalty. And the sum of the financial penalty would be increased in accordance with the number of offenses. Now, second question about the operation of the district's office of the member, whether it will still continue to operate under suspension. Now, we make reference to the Legislative Council's practice. During suspension of membership, the office would continue to operate. However, the member himself cannot act in the capacity of a council member. The third question. Now, please continue. He will ask follow-up question if he finds your answer unclear. Now, during the suspension period, there may still be work incurring operating expenses. So even when the member is not acting in the capacity of a member, there are still operating expenses, say for example, the utility charges and the rent of the district office and the salaries of the assistants. We are not disqualifying the member during the suspension period. It is just that during a certain period of time, the person will not be allowed to act as a member. So there are still operating costs to cover. Now, the last question. The legal fees pertaining to the interim injunction. May I invite the DOJ to give a reply? Thank you. Concerning the fourth question, that is the litigation or the legal cost. When the Secretary for Justice applied to the court for an interim injunction and the application is approved by the court of first instance, then the court of first instance would make an order in accordance with the legislation. The court has a discretionary power to make an order depending on the impact or the severity of the case in considering awarding cost. We don't think it is necessary to specify the handling of costs in this subsection. Thank you. Follow-up question, 72D brackets 3. Please be brief. We are running out of time. Well, maybe I should press the button for a second round. Yes, please do. Mr. Gibson Yang. Thank you, Chairman. Now, brackets 1C and brackets 4. 1C, suspension of functions and duties is one of the sanctions. So is there a specified duration of suspension? Will the suspension last until the end of the member's term? Well, will that be subsumed under Section 26A, that is, a member losing his membership? Brackets 4. Operating expenses shall be reimbursed during suspension. Well, brackets 3 says that a member must not act as a member if he is suspended. Well, if that's the case, maybe the operating costs should not be reimbursed as well. This is an awkward situation. The district office of the member will continue to run and there will be staff costs. Well, the office would say clearly that this is the office of, say, Mr. Kissen Yang. Well, it means that the office is operating in the capacity of the member. So will the office be required to cover the name of the office? And also, can the member use his name on the letter? Well, if a department receives a call from Mr. Kissen Yang's office, will you answer his call? Well, let's say if someone has ill intent and he is being suspended for a long period of time, and the suspension kicks in towards the end of the term. Well, if someone harbors ill intent, since operating expenses would be reimbursed, the person may hire a large number of assistants to incur a significant cost on the government. Well, maybe we should set some restrictions on the expenditure items for reimbursement, say rent, to avoid these cases. Well, we have not specified the duration of the suspension period, but we would make reference to the suspension arrangements of the Legislative Council. For first suspension, it would be 1 week. The second suspension within the same term would be 2 weeks. A third time would see the suspension period doubled, and so on. Now, whether the suspension period would last until the end of the term of the member, it really depends on the timing when the misconduct occurred. And also, we have to consider the cumulative principle. The intent of the suspension is not to disqualify the member. So even if the member is suspended until the end of his term, it doesn't mean that he has been disqualified. Now, reimbursable operating expenses, as I've mentioned, these are expenditure items on a reimbursement basis. Even if you close the district office, there will still be operating expenses incurred. You have to pay the rent, and you can't fire your assistants once you are suspended. So we are not thinking in the sense of we are not thinking suspension period lasting years. For very extreme cases, however, if the suspension period is very long, then the member's concern may be valid. Now, for operating expenses, for a claim made to the Secretariat, you have to provide proof of employment and so on. So it's not so simple that the member can hire a large number of assistants once the suspension kicks in. And also, with the amount of subsidy, not a lot of people can be employed. Well, I don't have a problem with the suspension period, but what about restricting the member to add more expenditure items during the suspension period to prevent a member from taking out a lot of purchase? Say, for example, computers during the suspension? Secretary, please. Thank you, member, for your views. Well, on considering the suspension arrangements, we are talking about suspension from meeting, and also the member will not be able to arrange for a meeting with someone in the capacity of a member. And also he can't tell someone to come to his office to meet with him because he is aware that his functions and duties have been suspended. Well, Mr. Kisson-Yang's worry is that a suspended member do some tricks to cheat the government on the reimbursement of operating expenses. Well, he will not be able to hire anyone new because he has been suspended from his office. And he can't make any purchase for the member's office. Now, these are reimbursement items. They prove the application for reimbursement has to be considered by the chairman of the district council, that is the district officer. Dr. Frankie Yan, thank you. Some questions on labor rights. Now, during the suspension period, will the member's assistant still has his job? Now, the member cannot arrange a meeting in his capacity, so what about the assistant? And can the assistant make a claim for work injury if he or she suffered an injury during the suspension period of the member? Or can you give us a brief answer? Director, thank you. In my previous answer, I said that during the suspension period, the member is still a council member and the assistant is still the assistant, so the labor rights will not be impacted upon. May I invite the DOJ to supplement? Thank you, Chairman, and thank you, Dr. Frankie Yan. Now, the short answer is the suspension of the member will not affect the employment relationship between the member and the assistant. In other words, the suspension will not make the employment contract void. I understand. Well, when we hire assistants, we are not hiring them in the capacity of a member. We hire them in a personal capacity. So what about work injury? With the definition of the term work relates to the suspension period. If there are work injuries, will the insurance cover the compensation for the assistants? Brief answer, please. Thank you, Chairman, and thank you, Dr. Yan. The scenario mentioned by the member, well, first, it will not affect the labor rights of the assistant. Well, we have to consider the specific circumstances under which the assistant got injured. So it is impossible to give you a concrete answer here. Mr. Lai Tong-kwok. Thank you. Section 72D brackets 1. Well, the Secretary may, after considering the reports of a supervisory committee on a member, consider imposing any of the following actions. Well, this is a very impactful section. However, the law doesn't mention whether the Secretary must give an opportunity for the person under charge to answer to his charge before imposing sanction. Now, the affected member will get a copy of the report. Well, he will be made aware of the charges against him. And then the role of the Secretary would be to consider the sanctions imposed. Well, how can we make sure that, well, in the interest of natural justice and procedural justice, the member should at least get a chance to offer mitigation to the secretary for a more lenient sentence. So maybe under Section 72D, a clause should be added to stipulate that the member will get a chance to make a representation for the secretary to consider before imposing sanctions.
HYAB. Thank you, Mr. Lai, for the comment. The district councillor concerned will have to be made aware of the report, and a chance should be given to him to make a representation or give mitigation. During the investigation of the supervisory committee, such arrangement will be made, but we will look into it and consider Mr. Lai's comment to give an opportunity to the district councillor concerned to give mitigation. Perhaps you can add it in your guidelines. I have another question in relation to Section 72D in relation to the suspension of the district councillor's functions and duties. We've had discussions about a district councillor's functions, but this is our first time seeing the term duties here. By duties, what do you mean exactly? HYAB. Thank you, Chairman. As mentioned, the duties will include the powers to be exercised by the district councillors. There are duties to be performed by district councillor. For instance, district councillors will have to provide certain services in their offices. We give them certain allowances and they will have to perform the relevant duties. This is related to the questions asked by other members. Well, the district councillor with misconduct will continue to operate his office and will continue to carry out his duties. So during the suspension period, technically, the district councillor concerned will have to stop operating the office until he resumes his duties. Is that consistent with your legislative intent? Thank you. As mentioned, the legislative intent is to stop the district councillor concerned from performing these duties as in the capacity of a district councillor. Chairman, I find these very conflicting. The district councillor will have to continue to carry out his duties during the suspension period, and he will still be hiring assistants and volunteers to help him carry out these duties. Well, during the suspension period, technically, the assistants and other staff members he hired should not be able to continue to do their jobs. So, what you said is in conflict with subsection 1 bracket C here, unless you make it clear enough. Any comments from the law draftsman? Thank you, Chairman. And thank you, Mr. Lai, for the comment. This is in relation to the policy. We will have a discussion with the Policy Bureau to see if we have to make this provision clearer. Mr. Moy. Thank you, Chairman. Thank you, Mr. Lai, for the question. Perhaps I can supplement here. Here we're talking about suspending the district councillor's functions and duties. We may have to consider the assistant hired by the district councillor, and we may have to make arrangements to tell people in the district that the district councillor concerned duties and functions have been suspended. So we'll have to look at the actual circumstances. The district councillor's office may have to continue to exist under certain circumstances. Sorry, Chairman. Yes, Secretary. On Mr. Lai's question, perhaps I can supplement as well. The policy intent is to continue to give operating expenses to the district councillor, because we want to avoid the following situations. During the suspension period, we don't want the services provided to people in the district to be affected. That's why we allow the district councillor concerned to continue to run the office. Also, someone will have to be at the district councillor's office to tell the residents in the district that the district councillor concerned will not be able to attend meetings during the suspension period. And this is in line with the arrangement and the Legislative Council. For Legislative Council members, there is a month's time for the member concerned. And that's why we are still giving the operating expenses to the district councillor. But we have to look at it on a case-by-case basis. Say a district councillor disrupts a DC meeting and the secretary imposes sanctions on that district councillor. However, services provided by the district councillor should not be affected. One of the misconduct listed out in the list of negative behavior is that a district councillor does not declare interest. Secretary, when imposing sanctions on the district councillor concerned, may say specifically that the office have to cease operation because of his behavior. To provide convenience to the public, the district councillor's office should continue to operate. But again, we have to look at it on a case-by-case basis. Mr. Peter Xu. I have a question about 72D subsection 2. It says here that the amount of financial penalty imposed is to be determined by the secretary. Is there a maximum amount of financial penalty imposed? Or will the remuneration received by the district councillor concerned the maximum amount of financial penalty that can be imposed on him? Second question. During the suspension period, the district councillor's assistant may have to still do their job. And during the suspension period, will the district councillor's assistant still be able to offer assistance to the residents in the district concerned? Thank you. Member asked about the amount of financial penalty, and we will make reference to the financial penalty imposed in Legislative Council. If a member causes a meeting to be terminated, we will impose a financial penalty in accordance with the remuneration of the member. We will deduct the member's remuneration depending on the severity of the misconduct. As mentioned, the number of misconducts will count, and the severity of the misconduct will also be considered. Second question is about whether the district councillor's assistant will will be able to continue to offer service during the suspension period. It depends on what kind of services the assistant is going to provide. For instance, if the suspension period only lasts for a week, the assistant may have to wait for a week when the district councillor concerned is back to do his job. But say if the assistant is only going back to the office to obtain information, well, members of the public during the suspension period will continue be able to obtain information from the office. Well, this is just an example. The district council's office will continue to operate. It's just that the district councillor cannot perform his duties in the capacity as a district councillor. Is that right? Yes. For instance, if the district councillor concerned wants to issue a letter, he will have to ask his assistant to do so. Well, he will be able to continue to provide service to the people in the district, right? Correct. Next, Mr. Chen Xiu-hong, 2 questions. I have a question in relation to that asked by Mr. Peter Xu and Mr. Lai Tong Kwok. I understand that there is clear definition of the term function in the bill, but for duties, what do you mean by duties here? Does that include district councillors' jobs to be carried out in his office? Well, the administration offered some explanations just now. I understand, but in reality, for instance, say a resident of the district seeks help from district councillor, and the district councillor staff may issue a letter on behalf of the district councillor's office to the government to offer help to the resident. Now we understand that during the suspension period, such work cannot be done, as the district council assistant will have to wait for a week when the suspension period ends to do all these jobs. So you have to make it clear in your guideline. This is not only affecting the district councillor himself, it affects the operation of his office as well. So you have to make it clear in your guideline. Subsection 6 of 72D provides that if the secretary is to impose sanctions on a district councillor, then the secretary will have to, as soon as practicable, notify the district councillor in writing. However, it doesn't say specifically here what kind of ways you are going to inform the district councillor concerned. Also, how are you going to inform members of the general public or people in the district concerned? If they are unaware of the suspension arrangement, they may still go to the district councillor's office to seek help. Will there be a system that you can follow when you inform members of the general public as well as the district councillor concerned? HYAB. Thank you, Chairman. We will make it clear in the guideline in terms of what kind of jobs can still be done during the suspension period. We will make all these clear in the guideline. Sorry, I'd like to add one point. Should you also set out clearly what the duties mean here? As mentioned, duties cover general work done by district councillors. Duties are works generally to be carried out by district councillors. So you can see duties as general work carried out by a district councillor. Member asked about how we will inform members of the public as well as the district councillor concerned about the sanctions. We will upload such information onto the website. Chairman, maybe we should consider setting it out clearly in the provision. You mean we should add it into the provision? Would it make it clearer if we set it out specifically in the provision? HYAB. Chairman, of course, we will inform members of the public as well as the district councillor concerned. Whether we should add it in the provision or make it clear in the guideline, perhaps I'll defer it to the DOJ. Mr. Moy, I understand where Mr. Chan is coming from. Do we have to make it specific in the provision? We can discuss it further with the Bureau. We can mention in the guideline if a suspension arrangement has to be made. We will inform the district council concerned in a certain way. We're of the view that it's enough to make it clear in the guideline instead of adding it in the provision. Mr. Ronick Chen. My question is similar to that asked by Mr. Peter Xu in relation to the financial penalty to be imposed by the Secretary. The provision provides that the penalty will be deducted from the District Council's remuneration. If you read the entire subsection together, it means that the financial penalty will not exceed the amount of remuneration to be received by the District Councillor concerned. The administration just now said that they will make reference to the financial penalty imposed in the Legislative Council. Well, the government is only making reference to that. It's not saying specifically the amount of financial penalty in the provision. Should you add a part stating that the financial penalty will not exceed the District Council's remuneration? Otherwise, it seems like there is no maximum amount you will impose in terms of the financial penalty. It can be $1 million or even $3 million, and that amount may exceed the total amount of remuneration received by a district councillor during his tenure. So perhaps you can add in the details here stating that the financial penalty to be imposed will not exceed the district councillor's remuneration, to make it clear. There were discussions about the operation of the district councillor's office during the suspension period. Well, subsection 3 bracket D or bracket C says that the district councillor concerned must not enjoy any corresponding entitlement. I suggest that you should add that the district councillor involved must not enjoy any personal corresponding entitlement, to make it clearer. That is, the district councillor concerned will be stripped of any personal corresponding entitlement, but the other operating expenses reimbursement that he is entitled to will continue be given to him. This will avoid all the misunderstanding or confusion. Thank you.
Thank you, Mr. Chen. Youth and Home Affairs Bureau, the ceiling to the financial penalty. Yes, we heard Mr. Chen's view. We can consider that. But I think Looking from the provision, the meaning is quite clear because the penalty has to be deducted from the member's remuneration, so it cannot exceed that amount of remuneration. And whether we should add the word personal to para C, we will discuss with the DOJ. Law draftsman, thank you. Now, for operating allowances, we rely on subsection 4. Despite subsection 3C, the person is entitled to be reimbursed the operating expenses incurred by the person during the period of suspension. As explained by the Bureau, the policy intent is to cover rent and also wages of the award officers. So we believe the current drafting is clear, but then we will consider the point made by Mr. Chen. Deputy Chairman. Thank you, Chair. In my previous speech, I made this point. We understand that details will be set out in the administrative guidelines to be issued later. When it comes to the power to take evidence of the supervisory committee and also the right of the member concerned to make representations, I think you should have some provisions here to make it complete. And as for 72E, there is no mention of the right of the member concerned to make representation. While you may say that you can set it out in the administrative guidelines, you should at least provide for such a right for the member concerned. Under 72D, we talked about Secretary may impose sanctions, and 72E is appeal against sanctions. So there seems to be a step missing between imposing sanctions and appeals against sanctions. Reading these provisions, it appears that we have not considered serious misconduct warranting disqualification, because I think the most severe sanction here is just suspension of the member's functions and duties as a member. Now, if we talked about misconduct, there may be cases where it is so serious that disqualification is required, but it appears that you have not catered for that in your bill. Even in the most serious case, the only sanction that can be imposed here is suspension from duties, but not disqualification. So the member concerned can still set himself out as a district council member. During the period of suspension, he has lost his qualification as a DC member on a temporary basis. It is really a big issue to allow his office to continue to operate. Because how can the activities of the office of a member not related to his duties as a district council member? So there seems to be some conflict here. While the secretary has referred to a scenario where the member is suspended from or barred from attending DC meetings, but during his period of suspension, he shouldn't be receiving inquiries from his residents, because addressing inquiries from guy phones and also referrals to other departments and bureaus are part of the duties of a DC member. It seems to be unclear here. Home and Youth Affairs Bureau. Well, to echo what the Deputy Chair said, my understanding is if a member is suspended from his functions and duties as a member, he's not allowed to do what's in subsection 3 ABCD. So the consequence of his being suspended can be found in subsection C. So now D, he's not to be regarded as a member for the purpose of section 86. So the four things are the consequence of his being suspended. A, he must not act as a member that doesn't involve his office. But for D, he is not to be regarded as a member for the purpose of section 86. Perhaps you want to explain. Yes, he must not act as a member. Of course, personally, he cannot act in his capacity of a member. He must not hold out as DC member. And 86D, section 86 is clear. There cannot be any protection for him. Should there be any lawsuits against him, that someone has incurred some loss as a result of this person acting as a member of the DC. Now, under 3D, the member would have lost all his immunity or protection under the bill. So 3 ABCD are the consequences of suspension, right? What about subsection 4? Any follow-up, please? That is about the work of the member's office. All right, during his period of suspension, he is not being disqualified. 3 A, B, C, D are the four things he cannot do during the period of suspension. His office will continue to operate because there are things that can be handled without the member being a member of a district council. But then there is contradiction here. You just told us that he has lost his status as a DC member. It's just that he cannot hold himself out as a member of the DC. Well, if he has not been disqualified, why can't he do so? He's just being suspended. Here's where the contradiction lies. He has to very clearly make clear that he has been suspended. You told us that he has not been disqualified. Disqualification is more serious than suspension. He has lost his disqualification. Now, you should put out clearly that his qualification has been suspended. You seem contradictory. So you have to make clear whether it is suspension of his functions and duties or suspension of his qualifications. The purpose of the section is not to disqualify him, so it is not about disqualifying the member. It's just that during the period of suspension, his functions and duties as a member are disqualified, as set out in subsection 3 ABCD. Members ask, how come we allow his office to continue to operate and that he is still entitled to be reimbursed for the operating expenses? Now, the period of suspension may be very short. It may be just a couple of days. If as a result, we cause the office to be unable to operate, then there may be implications involving labor rights, for instance. Now, when a DC member is suspended from duty, we do not want to impact on the services to the district. Now, if he continues to be in this office, claiming that he is still a district council member, or he arranged meetings with members of the public in his capacity as a DC member, that goes against the spirit of the suspension. But if the office is open for members of the public to come in and read newspapers, to photocopy documents, and to seek information, that can continue. Members are concerned that if the member is still entitled to seek reimbursement for the operating expenses of his office, will he abuse this privilege? But then, even though he has suffered financial penalty, there is no question of his regaining it through the fully accountable reimbursement system. The chair has made very clear that there are 4 things he cannot do during the period of suspension. He must not act as a member. That means you have not stripped him of his membership, right? This is very clear. And under D, he is not to be regarded as a member for the purpose of Section 86. All right, if he is not to be regarded as a member, there is no need for you to mention Section 86. You are talking about protection he can enjoy under Section 86. I cannot find anywhere you intend to strip him of his qualification. You're very correct. We are not disqualifying this member. It is just that he cannot act in this capacity. Can he, for instance, distribute his name cards? Now he can tell members of the public that he is a DC member, obeyed being suspended from duty for a couple of days. I think it's not very clear. First, we are not suspending his qualification as a member of the DC. Rather, we are only suspending his functions and duties. He cannot do what is set out under Section 3 A, B, C, D. That is very clear. The Secretary has been very clear, and I hope officials can be as clear in answering our questions. Please don't mix up the concepts. Otherwise, the scrutiny is going to be very protracted. Mr. Tommy Zhang. I also like to follow up on the same point. I think the drafting here is a bit confusing. During the period of suspension, I'd like to put this question to you. If I am suspended from duty and yet I work in my office, can I just cover my nameplate? I don't act as a member. You are still a DC member. You only suspended from your duties. But here it is said that I must not act as a member. Well, you may describe yourself as a member during suspension, perhaps 2 weeks afterwards. When the suspension is over, I am again a DC member. But I may have community officers working with me in my office. I agree with members that perhaps you should make it clearer here. Now you say that I must not hold myself out as a DC member. But can staff in my office claim to be DC members? Of course, there are, for instance, my assistant in the office would be informed of my suspension, can he just call members of the public claiming himself to be Tommy Cheung, a district council member? Although it's not mentioned here, but members or officials talked about a suspension period of 2 weeks or 1 month, and a service to the public should not be adversely affected. What if the suspension period is as long as 6 months? Will your thinking be entirely different? Ms. Mack. Thank you. As I said, now during suspension, a member is still a DC member, although he is suspended from duties, and therefore he cannot act as a DC member. He cannot invite somebody to meet with him in his capacity as a DC member. And if the name of the DC member is covered, now then this office is not a DC member's office, and so it is not entitled to receive the reimbursement of the operating expenses. So the person is still a DC member. It's just that he cannot act as a DC member in the interim. So I continue to use my letterhead and my name cards. What if I have arrangements with members of the public for meetings and other activities? When I made the appointment, I didn't know that I would be suspended. I have prior appointments with members of the public for meetings and activities. Will they have to be cancelled? Well, you can reschedule, and you can ask your assistant to assist. Still, my assistant will be assistant of Tommy Cheung, district council member, but you are not acting as a member yourself. I'd like to know whether the suspension will apply to my staff and assistants in my ward office. Because Tommy Cheung is being suspended, can my assistant tell members of the public that, well, I am the assistant of Tommy Cheung, a DC member under suspension, etc.? Now, if you have prior appointments with members of the public, and then when you are suspended, you have to inform the parties concerned that you are under suspension and you cannot meet with them in your capacity as a DC member. Now, if members of the public still want to proceed, that's okay. Now, if they want you to make referrals for them, then you cannot make referrals and make arrangements to meet with departments in your capacity as a DC member. You cannot act in your capacity as a DC member. Now, I'm a bit confused now. Well, if he meets with members of the public, he's still acting in his capacity as a DC member. No, he has to tell members of the public that he is under suspension. Well, there can be an informal chat with members of the public. He is not acting as a DC member. Can I use my letterhead to write to the chair? Now, while I am being suspended, I'm using my letterhead to write to this chairman, telling him that I have received such views and I am relaying such views to the chair. You can use You can act in the capacity of Tommy Cheung, but not in the capacity as a DC member. Now, I continue to use my letterhead, although I sign as Tommy Cheung. So, my letterhead reads Tommy Cheung, DC member, but in my signature, I sign the letter as Tommy Cheung. I won't mention DC member. Is that possible? we have to consider it on a case-by-case basis. I think the DOJ can advise whether there is an intention to mislead people into thinking that he is a DC member.
Can we get a simpler answer from the DOJ? Thank you, Chairman, and thank you, Mr. Tommy Cheung, for your question. Well, as the Secretary has explained, the meaning of the section is quite clear. First, the membership of the member has not been revoked. It is just that his functions and duties are suspended. Now, working on Mr. Tommy Cheung's example, the member must consider very carefully whether he or she should still act in the manner mentioned by Mr. Tommy Cheung. Now, if the constituents are not clear about the actual capacity of the member under suspension, then it would cause problems. Now, the law is very clear that it is just as the functions and duties are suspended. Chairman, you ask the member to beware of the consequence. Well, the consequence is very simple. That is an injunction order secured by the DOJ, and then there will be financial penalty. Well, that's simply the consequence. You can't rule out the fact that some people would still act unscrupulously despite the consequence. Mr. Gary Chen. Well, some members ask questions on whether the office would still be allowed to run. Well, actually, district council members only look to serve the community. So the Secretary said the office should be allowed to continue to operate because that would allow community service to continue. But let me give you some counter-example. Now, during the Black Letter violence period and under the previous term of the District Council, the council members have very close relations with the assistants. Well, sometimes it is not so much as the member instructing the assistants to do something. The reality is the assistants would do things on behalf of the member. Now, if the member acts inappropriately, then it is natural that his duties and functions are suspended. But you haven't dealt with his supporting team. If he's not allowed to act in member's capacity and the office is still allowed to run, then the assistant can still perform his agenda. Now, when you look at examples when the Legislative Council was attacked and so on, the council member might not be present outside the Legislative Council complex attacking us, but his assistant might be the one doing that. So assistants may still be able to act on behalf of the suspended member, and cause trouble. Chaos can still be instigated outside the meeting room. Now, normally, the office purpose is to serve the community. But what if the office is acting in defense of the suspended member rather than serving the community? Well, I believe everyone has good intent, but allow me to give you examples to the contrary. For the scenarios I have mentioned, when a council member is suspended from duties, should you also prevent or disallow the office to act in the capacity of the member? That is my worry. HYAB, thank you. Like Mr. Gary Chen said, we want to allow expenditure items to be reimbursed even under suspension because we want to ensure continuity of the office and also the services offered by the member staff. But we will listen to Mr. Gary Chen's views. We will consider your views. Maybe we should specify clearly in the guideline or even the ordinance that one of the sanctions to be imposed by the Secretary is to stop the operation of the office and also disallow reimbursements of operating expenses. Dr. Simon Lee, thank you. I echo Mr. Gary Chen's viewpoint. Well, I would do this experiment from the legal point of view. Now, the answer is clear. Suspension of functions and duties is one thing. Suspension of membership is another thing. But they are very similar concepts, and it is very confusing. Well, under a suspension, it is very difficult to prevent the member from claiming himself to be a member. There is no way you can stop a member from claiming to be a district councillor because under the law, he is still a council member. So he must not act as a council member, but he can still claim himself to be a council member. There is no way you can prevent this. The person is just merely describing his or her capacity under the law. So it is still lawful. So another alternative is to suspend the function of the person and the office entirely. It will reduce the likelihood that he still claims to be a council member. But according to my point of view, there is no way to completely eliminate the possibility. Thank you for your question. Well, whether a member can come out and tell others he or she is a council member, well, the person's functions and duties are suspended. So it is not incorrect for the person to claim to be a council member, but he or she cannot act in the capacity of a council member. That is, the person cannot give others his or her name card and suggest that he or she can help the constituents in the capacity of a council member. So he can still claim to be a council member under the 7th term, but he cannot act as a council member under the 7th term of district council. Mr. Stanley Ng. Now, it really depends on whether the government would like to enforce the sanctions stringently or in a more relaxed manner. Now, act as a member, there are many definitions under acting, including the operation of the district office of the member. So I think the office should not be allowed to run under suspension of the member. Of course, there will still be operating expenses incurred. We should allow reimbursements of operating expenses. This is reasonable. I think the law is very clear, and you shouldn't be interpreting the law relaxedly and allow operation of the office. I agree with Mr. Gary Chen. The office of the member should be asked to close until the resumption of duties of the member. Since you have said very clearly that the person must not act as a member, so that's my view. Secretary, thank you. As mentioned in my reply to Mr. Gary Chen, we understand where members were coming from. We will study their views carefully. Mr. Holden Chow, thank you, Chairman. I agree with Mr. Gary Chen's view. Now, on top of that, imagine that under suspension of the member, the assistant himself may think otherwise. So if you allow the office to continue to operate, the assistants may go out and tell stories to constituents in the neighborhood, and then it would affect the reputation of the district council. Now, the assistant has been working for the member for quite some time, and then the suspension may cause grievances on the assistant's part, and then he or she may act in contrary to the benefits of the district council itself. So I agree with Mr. Gary Chan. We should interpret this requirement more stringently. So that's a view. Mr. Kwok Wai Keung, second round. Thank you. In my second round, the administration said there would be a cumulative mechanism for the warning and the financial penalty. Now, the fine level would be increased exponentially. So would it be like that of the vehicle license punishment system? And also there is the question whether the office should be asked to close during the suspension period. Now, of course, the intent of office is to serve the community. Now, of course, as a labor union, we are concerned about the salary payments to the assistants under suspension. The assistant still has to live. So I think the office should be allowed to continue to run, but there are things we must consider. This includes the collaboration with departments. If a meeting has been scheduled before the suspension, then should the meeting be cancelled? Now, if it's just a meeting with the administration, then it can be rescheduled easily. But what if a meeting has been scheduled and arranged with residents in the neighborhood? A rescheduling of meeting may affect the well-being of the residents in the neighborhood. So the member cannot act as a member. So what if a constituent calls him a district councillor? Should he ignore the residents, or should he explain to the constituents that he is a member under suspension? Of course, there would be news that the member has been suspended, but what about the webpage of the district council? Will it make public the suspension order? Now, 72D(5), if a person's functions and duties are suspended, the person cannot attend a meeting of the DC, and the person will not be regarded as being absent from the meeting. So this is to address the concern that the absence during suspension would be counted towards absence in meeting for 4 consecutive months, and then the member would be disqualified. But there is another thing, though. Now, the secretary would issue guidelines on the expected behavior and performance of the council members. So there will be KPIs. And also there may be a task assigned to the council member by the chairperson before the suspension. So will that be counted towards the KPI as well? Please focus on the third question. Well, on the scenario where the person is being greeted by the constituents as a council member, and also for meetings scheduled before the suspension. Well, first thing first, the person has not been has not had his membership revoked, so he or she can still respond to the greeting. Well, there is another thing. When a person is being invited to preside over a certain ceremony, if he is under suspension, he may have to consider carefully whether he can still do that. And also, if a certain department has arranged a meeting including member and also constituents, then if the member is being put on suspension, the departments can still meet with the constituents because they want to help the public. So the meeting will still take place. Now, concerning the KPIs and work targets, those are set by the chairperson of the district council. Well, since the suspended member would not lose his membership due to absence in meeting, there will be no more punishments for the member if he or she cannot fulfill the KPIs. Mr. Lai Tong Kwok, thank you. Two questions and one viewpoint. We have spent quite a lot of time on exploring whether the office will still be allowed to run under suspension. Now, under Section 72D, brackets 1C, the drafting of the law is in a way that the secretary is being given discretionary power to impose sanction. A very lenient sanction can be imposed. Say, for example, the member is barred from attending 3 meetings, say. So I suggest adding this under the session, that is to suspend the whole or parts of the member's functions and duties as a member, whole or parts, in whole or in parts. So that will be much clearer. Maybe that would suffice to address all our concerns. Then we can simply leave this behind. Now, another 2 questions. 72D bracket 6. The secretary has the power to impose sanction on a member and inform the member in writing. Well, the written notice would inform the member of the details of the sanctions, but no justifications or grounds are required to be given. Now, there is an appeal mechanism, so on lodging an appeal, the member must appeal on the grounds. So I think you should add grounds for imposing a sanction as well, so that on dealing with an appeal application, there would be a ground for handling that appeal rather than considering unrelated things. Now, Section 86. Now, if a member is acting in bona fide under this section or other section, there will be a protection for the member against any civil liability. So when Section 72C kicks in, the member will lose this protection. Well, under suspension, the member simply cannot act in the capacity of a member. So it seems that this subsection is superfluous. But there is another question. Since the member has lost its protection, can I sue the member for anything he or she has done before the suspension kicks in? Have you considered that? Or maybe the HYAB will answer the first question and then the DOJ the second question. Thank you, Chair. Now, the 2 viewpoints mentioned by Mr. Lai Tong Kwok, we will consider them carefully, and DOJ will take the other question. Mr. Mui, thank you, Chairman, and thank you, Mr. Lai. On your last question, that is Section 72D brackets 3D. The law says the member is not to be regarded as a member for the purposes of Section 86. Now, Section 86 is the protection, legal protection for the member. Now, for a member under suspension, the person must not act as a member and must not perform the duties and functions of a district councillor. So under these scenarios, the member may still act in the capacity of a councillor or claim to be a council member. So we think we have to specify clearly that under suspension of duties and functions, the legal protections offered under Section 86 to a serving council member should cease to be valid as well. Thank you.
Mr. Kisson-Yang, second round. I have 2 comments. I believe with improved district governance, most district councillors will behave. Well, the examples that we're looking at, we're talking about suspension of duty for a week or 2. During the suspension period, services provided will be affected. I think what members said are reasonable. I'm just thinking whether all these can be made clearer in the provision or in the guidelines. Maybe you would like to set out clearly what behaviors should be avoided by district councillors. I don't have specific objections to the provision. However, in case there are district councillors who misbehave, then there should be a system in place to empower the secretary to impose sanctions depending on the severity of the misconduct. I think based on the circumstances, the government can decide whether the entitlement to the operating expenses reimbursement should also be suspended. I think you have to make it clear in your administrative guideline on how you're going to carry out subsection 3 of 72D. That is, you must not do anything for the purpose of carrying into effect the provisions of this ordinance or any other enactment conferring functions on the district council. There being no other questions, before we proceed to Section 72E, I have a question for HYAB. We looked at 72B, subsection 4. That is, Secretary may revoke or vary any guidelines, and the Secretary is empowered to do so under the provision. I understand that if the Secretary wants to amend the guidelines, the Secretary will not do it by way of subsidiary legislation. Will the government undertake to consult the relevant legislative council panels when the guidelines issued are to be amended? Thank you, Chairman. The mechanism set out in subsection 6 bracket A is a new mechanism. With the improved district governance, we will from time to time make reports to the government. We will report our work of the task force on district governance as well as the steering committee on district governance to the government from time to time. We'll now move on to Section 72E. We now come to the last section of this part. It's about the appeal mechanism. If the district councillor concerned is aggrieved by a decision made by the secretary, then he will have to, within 14 days, make an appeal to the chief secretary for administration. Subsection 3 here provides that the appeal will not suspend the decision unless the Chief Secretary for Administration decides otherwise. Subsection 4 here provides that the Chief Secretary for Administration may confirm, vary, or reverse the decision. For subsection 5, it provides that the Chief Secretary must issue a notice of decision made to the district councillor who made the appeal. Will the Chief Secretary for Administration provide reasons for his decision? He will have to provide reasons for his decision. I understand that this is subject to the judicial review, correct? Mr. Lai Tong-kwok, I have a simple question. Subsection 1 of 72E sets out that the district councillor concerned will be able to appeal. How will the district councillor make the appeal? In the form of writing, or can he do it verbally? I understand there were disputes in relation to that. In the future, there may be disputes regarding the appeal mechanism. Will you set out clearly how the district councillor should lodge the appeal? Second question, in relation to subsection 2, it says that the appeal must be made within 14 days after the date of the decision. It seems like the 14-day period will start counting on the day when the decision is made. Well, it takes time for you to serve the notice to the district councillor concerned. Should you specify clearly when you'll start counting the 14-day period? From the day when the decision is made, or from the day when the notice is served to the district councillor? Secretary. Thank you, Chairman. As mentioned, there will be a guideline setting out the investigation procedure, appeal mechanism, and the mechanism to notify the district councillor concerned. We'll set it all out clearly in the guideline. As to the question in relation to the 14-day period, we'll consider whether we have to make it clear in the provision. Sorry, I've asked my questions already. Any further questions from members? Legal advisor. Please switch on the mic for the legal advisor. Thank you, Chairman. Can the administration clarify on this point? You're proposing this appeal mechanism. According to the provision, the district councillor concerned can appeal to the Chief Secretary for Administration. If you look at subsection 1 of section 72B, it says that the Secretary may impose sanctions. Can the district councillor concerned appeal to the sanctions made by the Secretary as well? Anything to supplement by the law draftsman? Another point that I'd like to see clarification on. When the Chief Secretary for Administration varied the original decision made by the Secretary, say for instance a warning was imposed and financial penalty was imposed, will the Chief Secretary for Administration vary the decision made in relation to the sanctions imposed by the Secretary set out in 72D subsection 1? Well, our legislative intent is to allow the Chief Secretary to vary the decision made in relation to 72D subsection 1. Any other questions? If not, we will complete subsection item I. After the break, we will resume the meeting at 11:15 and we will continue with the scrutiny of item J. Thank you.